Hey, I'm nationwide disability attorney Nancy Cavey. I'm often asked, how do I approach client communications and meetings? Well, the answer is I work as a team. I am sort of the doctor, if you will. I'm the surgeon, and I have a staff of competent and qualified paralegals that help me with a case. Now, I don't defer everything to them or assign them everything in a case. I initially will talk with you. We'll talk about the strategy of your case. We'll talk about why they denied the claim and what we need to do to overcome a claims denial. I next get the carrier file, because without understanding what's in that file, it's hard to actually formulate and implement a winning appeal strategy. And you're involved in that process, because I send you a copy of the carrier's file so you can see the many reasons why they've denied your claim. I then formulate a strategy for determining how we're going to get your benefits. It might involve having you undergo my own independent medical examination or a functional capacity evaluation. If your doctor cooperates, I'm going to take their statement. I want to take your statement and that of family members and even other people who may be relevant, including former co-workers. Once we've got a game plan down, my staff is going to implement that. When we get the necessary medical records from your physician, when we develop the medical evidence, I sit down and I write your appeal letter. There's no one else in my office that writes the appeal. I do. I come up with the documentation to support your claim. And my appeal letters are anywhere from 25 to 65 pages long. They go into the disability carrier in a box called a shock and awe appeal. And I'm known in the ERISA disability industry for my shock and awe boxes. In fact, I'll be at mediation when a claims representative will say to me, listen, your appeal letter gave me a reason to rethink this claim. And so it really is important that you have a lawyer who understands the claim, but more importantly can write an effective appeal letter. Now, if the case doesn't settle, we file a federal lawsuit, and if necessary, in jurisdictions in which I'm not licensed, I will get local co-counsel. But I'm actually handling the file in conjunction with co-counsel. You can be assured that we'll keep you updated as to what's happening in your case, and you can be guaranteed that I'll be appearing with you at any mediation. I'll prepare you for the mediation, and we will have an opportunity to discuss in detail what's going to happen in that mediation, the value of the file, what I think the carrier is going to do, and we'll create a plan that will hopefully get you the benefits you deserve. Now, you have to understand that winning in the context of an ERISA disability case just might be settlement of your case, because in many policies there is something called a discretionary clause that lets the carrier have a license to steal. Because even if the judge disagrees with the decision, they can't necessarily overturn that wrong decision unless there are certain elements that have been met. And it's a bit like a climb uphill. Now, there are many instances in which cases don't settle at mediation, and we go forward on a motion for summary judgment, which is a set of legal pleadings that the court will review to determine whether or not there are sufficient grounds to overturn the claims denial. And an appeal from that decision can be taken to the circuit court. So obviously we're working together closely from beginning to end to get you the best resolution of your case that's possible for you given your personal circumstances.